What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And as always, before we start these things, I want you to like, subscribe, follow MMA Payout, follow The Legal Submission on YouTube, and check out our Twitter and the Substack. It would be great to do it. And if you want to know the ins and outs of the business and legal issues included in combat sports, you only know MMA Payout and the Legal Submission are your go-to sites. Now, in this edition of the Legal Submission, we are taking a detour from the UFC Antitrust Lawsuit and going into the fight for the class of plaintiffs that are going to go against the UFC. We're still waiting for the Ninth Circuit to render a decision as far as what it will do with the appeal filed by Zuffa. But in the meantime, the big date is October 31st, Halloween. Judge Richard Boulware has indicated that a status conference will take place in his courtroom in Las Vegas. One of the issues that I believe, will be discussed is the fight for plaintiffs in this case. Now, as we know, class counsel for Kung Lee and the fighters that initially filed this lawsuit are one set of the attorneys and the designated class counsel that will coordinate the lawsuit against Zuffa. However, the Sparacino law firm has a stake in this litigation, as it has 14 or 15 plaintiffs in this lawsuit. We know that the parties, the plaintiffs' counsel, have been fighting over the issue of whether or not it was ethically legal for the Sparacino law firm to solicit clients of the class. The class counsel for Kung Lee had filed with the court motion or some sort of pleading to prevent Sparacino law firm and another law firm, Scott & Scott, from soliciting their clients prior to Judge Richard Boulware's final decision awarding class status, class certification to the plaintiffs, the fighters. Now, the issue for Kung Lee's attorneys is that they had put in a lot of effort, time, effort, costs into this litigation, and they do not want other law firms to come swoop in and take potential clients that they might be representing in this litigation. Now, for a class action litigation, the court has already designated Kung Lee's attorneys at Berger Montague and the affiliated law firms to go ahead and represent them. But people that fall within the class of individuals can find their own attorneys if they so choose. So that could mean that they could have an attorney that is not affiliated with Berger Montague or the other law firms to assist them. That or the other alternative, of course, is to opt out of the litigation altogether. Obviously, most of the fighters that believe in this cause, started by Kung Lee and the other fighters, would want to be a part of the class action because there's potential to receive payouts from the litigation, whether it be a settlement or whether it be a court decision. So what has happened is Sparacino law firm, prior to the class counsel for Kung Lee, filed a motion to the court requesting a notice of some sort of indication, some sort of ruling that they be allowed to solicit clients of the potential class without being hindered, burdened, as they say in their papers, threatened or intimidated by the class counsel for Kung Lee. Obviously, Kung Lee's attorneys believe that the solicitation was done outside the scope of legal ethics. Now, there are rules related to communications with potential clients, actual clients, prior to or during a litigation. Essentially, the rules of professional conduct and the ethical rules indicate that you cannot contact someone that is already represented. That's the basic rule. Now, the question is whether or not the class counsel represented all of the potential people within the class. The other issue that was pointed out in the pleadings was whether or not the Sparacino law firm or other firms that may solicit have to indicate that there is class counsel already designated. So basically saying you technically have an attorney already, but you can choose another attorney. Now, this is kind of a hard issue to discuss for potential clients because, one, if you already have an attorney, why seek another? And then the second issue is why, are the attorneys that are designated, will they best seek out your interests? Now, every potential client has the right to choose their own attorney. Though the reason why we have class action lawsuits is because you can actually have one firm, one group of attorneys representing your interests without having to go through an individual set of issues and worries throughout a lawsuit. So basically, the class counsel answers the discovery for the whole class. You don't have to personally answer questions for the class of individuals. The class counsel does expend the costs for the litigation, meaning that they put up front the costs for experts, filing fees, copies, all these things that you don't really think about. The attorneys put up front and don't ask the client to put the costs up front first. Obviously, at the end of the case, there is reimbursement of funds and things like that they may have put out in front first. So, what has happened here in the potential fight between the firms? Well, first of all, the attorneys for the Sparacino law firm had provided a expert opinion as far as whether or not it was legal for the class counsel to intimidate or knock out other law firms seeking to solicit potential class members. The law firm, the attorney expert on behalf of Sparacino said, of course, that it was unethical for the plaintiffs in the lawsuit to go ahead and try to freeze out other law firms. And the thrust of that expert's opinion was that putative class members are not represented and that attorneys may contact them. So they cited several cases which stated that pre-certification communication with putative class members did not violate anti-contact rule because defendant had an equal right to access to its employees. And that's a particular case in California related to communications with potential class members. Of course, the class counsel for Lee rebuts this notion with their own expert, a UNLV law professor, who claims that one, it was illegal, unethical to contact class members, and in its declaration states that based on the concerns, one can argue that permitting relatively free attorney solicitation of unnamed class members acts as a hedge against self-serving behavior by putative counsel. But even if this concern were valid in many or even most class actions during the early stages of the matter, the concern largely evaporates in cases where the litigation has proceeded for several years, involved substantial attorney effort, developed facts, and articulated supporting law. At this point, class counsel has established itself as a faithful champion with a relationship to the entire class, much like that of the traditional lawyer-client relationship, in which the rules of professional conduct rule constitutes a bright-line rule and solid barrier against the type of solicitation pursued by Sparacino. So once again, we talk about this free rider concept in that class counsel for Lee has expended a lot of their time, effort, and energy in this litigation, and they are trying to defend that right against a law firm that will swoop in and take clients from them. The opinion by the UNLV professor seems to be a inference based on the factual scenario rather than checking in on legal cases. And in fact, the attorneys for Sparacino, the Sparacino law firm, come back in a reply brief citing that the UNLV professor is not even an expert in legal ethics, but is an expert in insurance-related issues. And then they go on to stomp on him by saying that even courts don't accept his expert opinion. Now, this fight between the law firms is getting a little personal, as in its response brief, the class counsel for Lee had claimed that Sparacino law firm, class counsel for Lee has put in its response brief a LinkedIn chat from the founder of the Sparacino law firm, which does not put him in a great light. And the Sparacino law firm comes back and claims that the attorneys for Lee submitted a false declaration. And that declaration related to Antonio McKee. And so what had happened is that as evidence of soliciting clients that already were represented, the Lee attorneys provided a declaration of Antonio McKee stating that they received several emails from Sparacino law firm about signing up to represent him in the Lee lawsuit. Now, the Sparacino law firm had rebutted that assertion by stating that it was actually Antonio McKee that went ahead and contacted the Sparacino law firm. But even though they rebutted that assertion by Lee counsel, it was in relation to solicitation that McKee had received. So the question is, was the solicitation legally ethical, or was McKee responding to solicitation and did not tell the attorneys for Sparacino that he was represented already? It could be a case that McKee was shopping around, or he just didn't know what his legal rights were. So October 31st will be the day that I believe that Judge Boulware will clarify all of these issues, whether or not the Sparacino law firm can solicit clients, whether or not they will be barred at this point going forward from entertaining other clients. These parties, these attorneys will have to work together later on against Zuffa and the UFC, because the parties will have to at some point collaborate and devise some sort of strategy. The Sparacino law firm does represent attorneys. I mean, does represent fighters in this piece of litigation. So this point going forward, or at not this point going, so this will come up if this goes to trial. We will always keep abreast of the UFC lawsuit, and we'll also talk about some other issues later on this week. It's the Legal Submission. Jason Cruz, thank you very much. Have a great day.